All right, peace and blessings. It's October the 12th, Saturday, the year 2019. We're just a few weeks away from November the 4th, which is Schaeffer's resentencing date. November the 4th, right? 2019. A document has been sent to me. It's 50 pages. You can go download this document at yearofjubilee.com. And you can read it yourself. If you want to stick around with me, I'm going to read it. And since I'm going to read it, I thought I would turn on the recorder and I'll put it out on YouTube for people who would prefer to hear it rather than read it themselves. This is called the Defendant's Resentencing Memorandum. It's, I guess, put together by Michael Filipovic, Federal Defender Ann Wagner, Assistant Federal Defender, attorneys for Francis Schaeffer Cox, Federal Public Defender for the Western District of Washington. It gives their address and phone numbers and email addresses, which I will not read. Table of Contents, Section 1, Introduction. 2. The nature and circumstances of the conspiracies offense in light of the Ninth Circuit's Memorandum opinion. 2A. The nature of offense is limited to a single government theory, Mike Anderson's database. B. The database conspiracy was expressly contingent on objectively unlikely events, the imposition of martial law, characterized by mass arrest and purges as in Stalin's Soviet Union, and the identification of any government employees who were carrying out such arrest. C. The facts underlying this conviction have never before given rise to federal criminal liability. They would not be sufficient for conspiracy liability in the First and possibly Seventh Circuits, and a similar militia case was dismissed with prejudice by a district court in Michigan. D. In comparison with other uncompleted conspiracy to murder convictions to which the guideline would apply, Cox's conduct was far less dangerous and reflects substantially less culpability. 3. Imperfect entrapment is a strong mitigating circumstance not previously argued or considered, and it supports a significant departure and variance in Mr. Cox's sentence. A. Background to the involvement of informants Bill Fulton and J.R. Olson. B. Inducement and threats by Fulton and reluctance by Cox. C. Inducement by J.R. Olson and reluctance by Cox. D. Cox's decision and preparations to flee as powerful evidence of reluctance. E. The evidence of imperfect entrapment is a mitigating factor. Establishing Mr. Cox is less morally blameworthy and less dangerous than someone who would eagerly pursue an agreement and a plan to kill federal employees. Section 4. Mr. Cox's mental health and the court's concern about future dangerousness. A. The court was misled by the psychological evaluation presented at the first sentencing hearing. B. Concern about Mr. Cox's ability to influence others. C. None of the federal employees identified by the government for the conspiracy to murder charge were placed in actual danger of physical harm. D. Mr. Cox's outrageous and offensive statements. E. Cox's ability to find pro-social avenues to address conflict and to discern more meaningful solutions to problems. Section 5. Conditions of confinement and danger in prison should be considered in determining the length of Mr. Cox's sentence. Section 6. Defense objections to probation guideline calculations. A. The 3A1.2b adjustment does not apply because Mr. Cox was not motivated to murder the 3 federal employees on Anderson's notepad because of their status as federal government employees. Section 7 is conclusion. Part 1, Introduction. The Ninth Circuit Court of Appeals vacated Francis Schaeffer Cox's solicitation to murder federal officers' conviction. vacated his remaining sentences and remanded to the district court for resentencing. 705 Fed. When it does a bunch of numbers and does some sort of case precedent law and it cites all these numbers, I am not going to read that. If you want to know all the nitty gritty, you're going to have to download this document from yearofjubilee, spelled with 1e.com. Okay, to the district for resentencing, 705 blah blah blah. This is a plenary or unrestricted and comprehensive resentencing, United States versus Matthews, 278 blah blah blah. En banc. The court reversal of Mr. Cox's solicitation conviction and the limited basis upon which it affirmed his conspiracy to murder federal employees conviction puts Mr. Cox's case in a much different light for resentencing. In addition to addressing how the reversal of the solicitation conviction affects the sentencing analysis, the defense will present new information and evidence not provided to the court at Mr. Cox's first sentencing hearing, including information from discovery materials received before trial and discovery provided after the first sentencing hearing, information obtained from the Freedom of Information Act request, and information from defense investigation. We also provide the court with the report of Dr. Mark Cunningham, sealed Exhibit A, and the reports from the BOP mental health professionals, sealed Exhibit B, debunking the psychological evaluation by Dr. Robin Ladeau, which misled the court into concluding that Mr. Cox had serious mental health issues requiring custodial treatment, suggested future dangerousness, and thus he needed to be specifically deterred by a long sentence. The court is also presented with additional and different legal grounds for mitigation, including imperfect entrapment, a recognized ground for downward departure not presented to or considered by the court at Mr. Cox's first sentencing hearing. Objections to the probation office's revised guideline calculations are set forth. Where are we at? Hold on, I got a page. The court is also presented with additional and different legal grounds for mitigation, including imperfect entrapment, a recognized ground for downward departure not presented or considered by the court at Mr. Cox's first sentencing hearing. Objections to the probation office's revised guideline calculations are set forth below and in the defense letter of objections sent to U.S. Probation on March the 22nd, 2019, Exhibit 1. Schaeffer Cox has been in prison since March the 10th, 2011, a period of almost 104 months, and he has served over 10 years of his term of imprisonment. We respectfully request that Mr. Cox be sentenced to a total term of no more than 120 months of imprisonment. Section 2. The nature and circumstances of the conspiracy offense in light of the Ninth Circuit Memorandum opinion. Among the recognized grounds for variance from the advisory guidelines range are when, as the guidelines themselves foresee, the case at hand falls outside the heartland to which the Commission intends individual guidelines to apply, as well as the guideline sentence itself fails to properly reflect 3553A considerations, Rita versus United States, blah, 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 a district court's decision to vary from the guidelines for an outside the heartland case is entitled to the greatest respect. Kimbrough versus United States, blah, blah, blah. Here, Mr. Cox's conviction for first-degree conspiracy to murder federal employees based on an anxiety-fueled agreement to resist if the remote possibility that Stalinesque mass arrest and purges at the hands of government officials came true is at the extreme margins rather than the heartland of the USSG blah 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 guideline for conspiracies to murder, as well as the blah 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 enhancement for official victims. Indeed, the facts underlying this conviction would not be sufficient for a conspiracy conviction in the First Circuit, and a similar militia case was dismissed with prejudice by a district court in Michigan. Similarly, the fact that this offense is a far from typical example of a first-degree conspiracy to murder means that the nature and circumstances of this offense suggest a far below guideline sentence. See 18 U.S.C. blah blah blah. there's a footnote number 1 that says Mr. Cox also contests the application of the blah 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 adjustment. See section 6. Part A. The nature of the offense is limited to a single government theory, Mike Anderson's database. The first step in characterizing the nature of the offense is to determine what is left of the conspiracy conviction after the Ninth Circuit decision upholding the sufficiency of the conviction by striking down the solicitation count. It is important to keep in mind that these two crimes share an identical jurisdictional element. The target of the murder plot or solicitation must be an officer or employee of the United States, and both are subject to self-defense arguments. See 18 U.S.C. blah blah blah. Although the Ninth Circuit's memorandum opinion could have been clearer, a careful reading of the opinion in the context of the briefing before the court shows that only Anderson's database provided sufficient evidence to uphold the conspiracy conviction. The government had argued to the Ninth Circuit that there were 3 separate theories supporting the conspiracy conviction. Point: Anderson's database of state officials with a separate notepad listing 3 names of federal employees that Cox had provided, but which Anderson never researched or added to the database. Government answering BR docket 126 at blah blah blah. The KJNP King James North Pole security detail providing defense against fictional federal assassins. ID Ninth Circuit blah blah blah. The footnote at the bottom of page 6 says, notably, the theory that the Ninth Circuit based its sufficiency holding on what, not necessarily the sole theory, that the jury agreed conferred liability for the conspiracy conviction. Indeed, because the government's closing argument relied heavily on the KJNP theory, see docket blah blah blah, and the jury convicted Mr. Cox of the solicitation count, which was based entirely on King James North Pole, it is likely that the jury's conclusion regarding conspiracy liability relied either in part or in full on the discredited KJNP theory. Point: the 241 discussions in which Cox, the government informant Olson, Barney, and the Vernon debated whether to adopt a plan in which 2 state employees would be arrested if one of their group were arrested, or 2 state employees killed if one of them were killed. ID Ninth Circuit blah blah blah. On reply, Mr. Cox argued that each of these theories lacked federal jurisdiction because there was insufficient evidence of the element of the offense requiring the target of the murder plot to be an office or employee of the United States. 18 U.S.C. blah blah blah, citing to United States versus Fiola. Hold on. Fiola. Where the object of the intended attack is not identified with sufficient specificity, as to give rise to the conclusion that had the attack been carried out, the victim would have been a federal officer. It is impossible to assert that the mere act or of agreement to murder poses a sufficient threat to federal personnel and functions so as to give a rise to a federal jurisdiction. Reply BR docket blah blah blah. On KJNP King James North Pole, in addition to federal jurisdiction, Mr. Cox argued that there was no conspiracy to murder because the security detail was providing self-defense against a fictitious assassin team. ID Ninth Circuit blah blah blah. He separately argued the solicitation conviction based solely on King James North Pole was insufficient for the same 2 reasons: federal jurisdiction and the self-defense objective that negated the intent to have others murder with premeditation and malice aforethought. ID blah blah blah. As for 241, in addition to federal jurisdiction, the briefs pointed out that the discussion showed there was no actual agreement between the co-conspirators to adopt 241. Indeed, Cox's definitive plan for the day he planned not to appear in court was, and then at the bottom of page 7, footnote 3 says, because the jury hung on Barney's conspiracy count, docket 432 at 3, it is clear that there was no jury unanimity as to the question whether any agreement between Cox and Barney to murder existed. Cox's definitive plan for the day he planned not to appear in court was trying to lay low Monday and avoid, if they're coming out with a bench warrant, avoid it and try to hit them with paperwork every way I can. ER 412. In the event that Cox were arrested or killed, he suggested, the thing you could probably get everybody to go in on, agree, is just raise hell by having picketing and just like, well, not quite a riot, but almost, and on the radio and on TV and sit-ins and just every kind of, peaceful protest and just get everybody's panties in a wad. ER 412-13, blah, blah, blah. See underlying citation at Exhibit 2 at 38. Tellingly, the government admitted at closing arguments that the 241 topic was the subject of a roundtable conversation and a debate, rather than ever characterizing it as an agreement. Docket 646 at 87. And Coleman Barney's attorney told the jury without objection that the 241 stuff is not charged as a crime. It's one of the 4 weeks of trial out of the 5 weeks that doesn't pertain to these weapons and charges of murder charges. With respect to Anderson's database, meanwhile, Mr. Cox argued to the Ninth Circuit at length that a contingent conspiracy whose objective likelihood was remote, such as an agreement to kill the perpetrators of unlawful mass arrest only if Stalin-esque martial law was being carried out in the United States, was not sufficient to confer conspiracy liability at all, citing precedent in the First Circuit holding such evidence insufficient. See opening BR docket 112, blah, 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 United States versus Palmer, blah, blah, blah. Liability for a conspiracy attaches only where the government can show that the defendant reasonably believed that the conditions would obtain. Reply BR, Ninth Circuit, blah, blah, blah. He also argued that under FIOLA, the contingency relating to the jurisdictional element was also insufficient. Whether the database would be used at all depended on 2 separate developments. First, the imposition of martial law, mass arrest, purges of various groups, and second, the identification of persons responsible, identifying who was doing it, only if the database contained the name of someone who had a hand in the enforcement of martial law. Did Anderson and Cox contemplate killing them before they could come for us, as Solzhenitsyn wished his countrymen had done? Cox and Anderson did not contemplate killing anyone in the database unless they were responsible for mass arrest or mass purges, because Cox and Anderson never identified any federal employee as one of the people carrying out mass arrest pursuant to the imposition of martial law. FIOLA forbids a Section 1117 conviction on these facts. Reply BR Ninth Circuit, blah, blah, blah. See underlying citation at blah, blah, blah. In light of this briefing, the Ninth Circuit's memorandum opinion becomes more clear. The Ninth Circuit held that the solicitation conviction, which it recognized was based solely on the King James North Pole episode, see memorandum blah, 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 was constitutionally insufficient for 2 independent reasons. At 4, first, responding to the defense's self-defense arguments, the court held that no rational trier of fact could conclude that the circumstances surrounding the formation of the security team for the television station event strongly confirmed that the defendant actually intended for anyone to commit first-degree murder. Quoting United States versus Stewart, blah, blah, blah. Second, the Ninth Circuit held that because the federal hit team that the security team was supposed to guard against did not exist, there was insufficient federal jurisdiction, insufficient evidence that the target of the solicitation was an officer or employee of the United States, citing United States versus FIOLA, blah, blah, blah. As this court intuited during the trial, the fact that the fictitious federal assassins might as well been little green men from Mars also eliminates a major basis for the conspiracy conviction. See docket 638 at 32, where the federal assassin simply did not exist. there was insufficient evidence of federal jurisdiction for the conspiracy conviction on the King James North Pole theory, just as there was insufficient evidence for the solicitation conviction on this theory. The self-defense objective also negates the mens rea required for a first-degree murder conspiracy on the King James North Pole theory. But the Ninth Circuit ultimately upheld the conspiracy conviction by ruling against the defense on two arguments concerning Anderson's database. Objectively unlikely contingent conspiracy in federal jurisdiction, the Ninth Circuit ruled that there was sufficient evidence because defendant and his co-conspirators agreed to attack government officials, including federal officers, in the event of certain conditions that they subjectively thought were likely to occur. Memorandum OP, Ninth Circuit, blah, 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 emphasis added, and that this scenario gave rise to sufficient federal jurisdiction, i.d., read in context, this is an unmistakable holding that Cox's conspiracy conviction is now premised on a single theory, Anderson's database. Only with respect to the database theory did the government have evidence of an agreement with regard to federal officers, the three names given by Cox to Anderson, but which Anderson never researched or added to the database. And only with respect to the database theory had the defense argued that any subjective belief in the likelihood of a contingency was not enough, that it had instead be objectively reasonable belief. Of course, the Ninth Circuit did not hold that an objectively unlikely contingent conspiracy to resist Stalinesque martial law fell within the heartland of the offense of conspiracy to murder. A question reserved for this court on resentencing, it does not. Footnote 4 at the bottom of page 10 says, although the Ninth Circuit stated that a rational trier of fact could also conclude that the agreement standing alone constituted a sufficient threat to the safety of a federal officer so as to give rise to federal jurisdiction, this question was never actually asked of the jury. Part B. The database conspiracy was expressly contingent on objectively unlikely events. The imposition of martial law characterized by mass arrest and purges as in Stalin's Soviet Union and the identification of any government employee who were carrying out such arrest. The nature of the remaining database theory is an expressly contingent conspiracy that was unlikely to ever occur. The theory involved a discussion between government witness Mike Anderson and Cox during the summer of 2009 about the possibility of government collapse and the ensuing imposition of Stalinesque martial law, by which they meant the use of mass arrest and purges by the government. Docket 629 at blah blah. Anderson testified under immunity that he and Cox discussed creating a database of government employees which they could use to help identify who was carrying out the mass arrest and purges, ID at blah blah, alluding to a quote out of Alexander Solzhenitsyn's Gulag Archipelago. Anderson explained that in the event of such mass arrest, we would want to be able to protect ourselves rather than just lay down and let it happen. ID at 57. The quotation Anderson was referring to reads in full. What would things have been like if, during periods of mass arrest, as for example in Leningrad, when they arrested a quarter of the entire city, people had not simply sat there in their lairs, paling with terror at every bang of the downstairs door and every step on the staircase, but had understood that they had nothing left to lose, and had boldly set up in the downstairs hall an ambush of half a dozen people with axes, hammers, pokers, or whatever else was at hand. Alexander Solzhenitsyn, The Gulag Archipelago, 1918 through 1956, at 13 N.5, 1973. Whether the database would be used at all depended on two separate contingencies. First, government collapse and the use of mass arrest in Stalin's Soviet Union, and second, the identification of persons responsible for those mass arrests. Although Cox gave Anderson the names of 3 federal employees, Nanette Curtis, Tom Studler, and Trina Bucamp, Anderson did not add them to the database and did not research them. The names were buried and forgotten until the raid on Anderson's property in March of 2011. And although Anderson also independently encountered the name of a federal marshal, there was clearly no agreement between Cox and Anderson to murder him, because Anderson never told Cox a name or anything about him. Docket 629 at blah blah. Apart from the notepad obtained during the raid of Anderson's property, none of these four names of federal employees appear anywhere else in over 12,000 pages of transcripts of the surreptitious recordings that government informants made of Cox, Olson, and Fulton, Barney, or the Vernons. If the co-conspirators were intent on murdering any of them, they certainly had an odd way of showing it. Part C. The facts underlying this conviction have never before given rise to federal criminal liability. They would not be sufficient for conspiracy liability in the First and possibly Seventh Circuits, and a similar militia case was dismissed with prejudice by a district court in Michigan. The fact that this conspiracy conviction is an extreme outlier is demonstrated by the fact that counsel has been unable to locate even a single other murder conspiracy conviction for conduct as attenuated and conditional as this one. In the only other federal murder conspiracy case counsel has been able to identify addressing a scenario that could reasonably be described as contingent, United States versus Gartman, blah, 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 the agreement was that if the conspirators were successful in murdering the first target, they would proceed to murder the other three targets, including two federal employees. ID at footnote 3. The defendant went so far as to offer the co-conspirators a reward of $30,000 for each federal target. ID at footnote 1. Unlike the contingent conspiracy, here, the Gartman conspiracy concerned a contingency that was entirely within the conspirators' control. A contingency of successfully murdering one target cannot be analyzed to the purely external contingency of government collapse and Stalinesque mass arrest and purges. The type of contingent conspiracy at issue here is not only rare, it actually would not have amounted to a crime in at least one other jurisdiction. According to the First Circuit, liability for contingent conspiracies should attach if the defendant reasonably believed that the conditions would obtain. United States versus Palmer, blah, 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 citing United States versus Dworkin, blah, blah, blah. If, as here, the contingency was an objectively unlikely event, on a historical scale, the imposition of Stalinesque mass arrest and the purges here in the United States, liability would not attach. The question whether Cox's conduct would have amounted to a conspiracy in the Seventh Circuit, meanwhile, is an open question. We need not decide if this case how to deal with a situation where an agreement is conditioned on an event that is highly unlikely ever to occur. United States versus Podolsky. Blah, blah, blah. Stalinesque martial law is highly unlikely to ever occur in the United States, where individual due process and trial by a jury of one's peers are rights enshrined in the Constitution, so liability might not have attached in the Seventh Circuit either. One case that can be profitably compared to the facts underlying the conspiracy conviction here, meanwhile, ended in dismissal with prejudice. When Cox's prosecutors were trying to fit the unusual facts of this case to some federal crime, they first had the idea of charging him with seditious conspiracy, as another case concerning militia members had been charged in Michigan. See Exhibit 3. They sought the search warrant in the Michigan case, called the prosecutors on that case, and after reading the case law, Mr. Scrocky suggested that the sedition statute, 18 U.S.C. blah blah, is equally applicable here. Exhibit 3 at blah. He then emailed the FBI agents working the Cox case, instructing them on the Huttery warrant, check out the seditious conspiracy charge. If they hand out a list of targets and orders to go active, if Huttery is an example, I think we might be in a better spot to consider it. Exhibit 3 at 2. The Huttery militia members were charged with inter alia, seditious conspiracy in violation of 18 U.S.C. blah, which carries a maximum term of imprisonment of 20 years. See indictment, docket 4 at 3-7, United States versus Stone, blah, blah. The general concept of the conspiracy, according to the indictment, provided that the Huttery would commit some violent act to draw the attention of law enforcement or government officials, which would prompt a response by law enforcement. Possible such acts, which were discussed, including a member of law enforcement after a traffic stop, killing a member of law enforcement and his or her family at home, ambushing a member of law enforcement in rural communities, luring a member of law enforcement with a false 911 emergency call, then killing him or her, and killing a member of law enforcement, and then attacking the funeral procession motorcade with weapons of mass destruction. Once such action was taken, Huttery members would then retreat to one of several rally points where the Huttery would wage war against the government and be prepared to defend in depth the tripwired and command-detonated anti-personnel improvised explosive devices, IED, ambushes, and prepared fighting positions. It is believed by the Huttery that this engagement would then serve as a catalyst for a more widespread uprising against the government. ID docket 4 at 4-5, ultimately Cox's prosecutors abandoned this charge, but they continued to pursue this basic theme all the way through closing arguments, suggesting conspiracy to murder federal officials wasn't really the point. The reason we're here this morning is because you've seen over the past 6 weeks evidence that Cox, Barney, Vernon are working on a plan. They're working on another form of government. And in the long term, we're not telling you that it was going to happen today, that it was going to happen tomorrow, that it was going to happen next week. Mr. Cox possessed a machine gun. Mr. Cox wanted grenades. Mr. Cox had a silenced pistol. Mr. Cox had a militia, a lot of other entities. He was using it to upswell his stock in Fairbanks, and he was doing it to form the sovereign republic of Schaeffer Cox. That fact we submit is indisputable. Docket 646 at blah blah, emphasis added blah blah. Meanwhile, in Michigan, the district court judge ended up granting Rule 29 motions as to the seditious conspiracy charges, ruling that although the lead defendant brings up the idea of murdering an officer and attacking the funeral procession, nothing resembling an agreement to spark an uprising with the federal government is reached during this conversation. Defendants toss out ideas of ways in which to kill police that are often incredible. More importantly, they never come to a consensus or agreement on ways in which to oppose federal agents by force. Stone even states there's 101 scenarios you can use. This back and forth banter, like the other anti-government speech and statements evincing a desire, even a goal to kill police, is simply insufficient to sustain the seditious conspiracy charge. It requires an agreement and a plan of action, not mere advocacy or hateful speech. Order of acquittal, docket 767, United States versus Stone, blah, blah. Emphasis added. These facts are more serious than the facts underlying Cox's murder conspiracy charge, and yet they gave rise to acquittals. Had the government charged seditious conspiracy in Cox's case, the real gist of the murder conspiracy charge, Cox might well have been acquitted. It is also at least possible that with better legal representation at trial, Cox could have had a shot at acquittal based on a similar arguments against the murder conspiracy. See blah blah. You must find that there was a plan to commit at least one of the crimes alleged as an object of the conspiracy, with all of you agreeing as to the particular crime with which the conspirators agreed to commit. The fact that Mr. Cox's conduct would not have given rise to conspiracy liability in the First Circuit and might have led to acquittal had the real gist of the offense, according to the government, been charged, also weighs in favor of a much reduced sentence here. Part D. In comparison with other uncompleted conspiracy to murder convictions to which a guideline would apply, Cox's conduct was far less dangerous and reflects substantially less culpability. The nature of the conspiracy and surrounding circumstances in Cox's case means it was less likely to be fulfilled and also reflects less culpability compared to heartland offenses. Scholars and courts have long worried about the potential breadth of conspiracy liability. See Cruel Witch versus United States, blah, blah, blah. The looseness and pliability of the conspiracy doctrine present inherent dangers which should be in the background of judicial thought wherever it is sought to extend the doctrine to meet exigencies of a particular case. Legal scholars have been particularly concerned with the grafting of conspiracy liability onto expressly conditional agreements. After all, contingent conspiracies disrupt the ordinary calculus as to what point in the continuum between preparation and consummation the likelihood of a commission of an act has become sufficiently great that the criminal intent sufficiently well formed to justify the intervention of the criminal law. Fiola, blah, blah. Professors Larry Alexander and Kimberly Kessler have termed liability for conditional purpose conspiracies radical. Larry Alexander and Kimberly D. Kessler, Mens Rea and Inchoate Crimes, 87, blah, blah. As a thought experiment, they asked readers to consider John and Jack, who agreed after buying a ticket in the lottery that if they should win the jackpot, they will murder their wives and spend their millions on high living. This rule would label this agreement a conspiracy to murder, despite the fact that John and Jack's chance of winning is infinitesimal. Then Professor Neil Katyal has argued for concrete limitations to the MPC's conditional purpose doctrine. The criminal law should punish activity where people genuinely intend to fulfill their illegal aims and where the chances of their doing so are high. But neither the deterrence nor retribution is served by criminalizing threats with remote condition triggers. Neil Katyal, probable failure of conditional purpose, 32, blah, blah. Although Cox was convicted of conspiracy to murder, he did not genuinely intend to fulfill the murder of the three federal employees on Anderson's notepad. Instead, he wished to prepare for the remote conditional trigger of Stalinesque martial law, and did not know whether any of the individuals he named would end up being responsible for carrying it out. Sealed Exhibit A at 1416 describing Cox's prepping behaviors. After Anderson wrote down the names, Anderson did not look up their addresses or anything else about them and did not add them to the database. Martial law did not come to pass. The Ninth Circuit held that these facts constituted a sufficient threat to the safety of a federal officer so as to give rise to federal jurisdiction. Memorandum, Ninth Circuit, blah. But under the Ninth Circuit's ruling, even an infinitesimal threat, to use Professors Alexander and Kessler's terminology, suffices. But precisely because of the highly unlikely contingency, Cox's theory was far less likely than a non-contingent conspiracy to be fulfilled. And although conspiracies are often thought to present greater danger than a person acting alone, the group decision-making in Mr. Cox's case led to arguably better decisions and less violence, compared to a plan for violence by a lone wolf. The logic of prosecuting conspiracies, despite the absence of actual violence or other antisocial behavior, is often premised on the purported danger of group action and the relative ease with which it can go undetected. See Callahan versus United States, blah, blah. Footnote 5 at the bottom of page 17. Although the government informant Olson heard about the database and following instructions of his handler, excuse me, Footnote 5. Although the government informant Olson heard about the database and the following instructions of his handler Sutherland sought the database from Anderson, Anderson destroyed the database rather than give it to him. Docket 401, blah, blah. Olson contacted Anderson for the list. Docket, blah. Sutherland asked Olson to ask. Conspiracy liability also cannot be based on an agreement between a government informant and a defendant. United States versus Escobar, blah, blah. 1961. Concerted action both increases the likelihood that the criminal object will be successfully attained and decreases the probability that the individuals involved depart from their path of criminality. See also Pinkerton versus United States, blah, blah. But outside the law of conspiracy, many theorists recognize that the exchange of opinions with other checks our partiality and widens our perspective. We are made to see things from their standpoint, and the limits of our vision are brought home to us. John Rawls, A Theory of Justice, blah. This institution is backed by empirical research showing that decisions made by a group are often better than a decision made by a single individual, and put into practice through the widespread use of groups of people to make important decisions, among them juries, appellate judges, and the Supreme Court. See Cass R. Sunstein, blah, 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 blah. Blah, blah. In Mr. Cox's case, a group discussions contributed to a rejection of the 2-for-1 concept, despite the encouragement of the government informant Olson. See Exhibit 2. Regarding Anderson's database, the involvement of Anderson, an independent decision-maker who was not in regular contact with the conspirators, meant that he could destroy the database when the potentially dangerous co-conspirator, Olson, sought to access it. Docket at blah. Group decision-making in this case inhibited violence rather than inflaming it. Cox's agreement with Anderson is also clearly less culpable than a non-contingent conspiracy to murder. Many readers of Gulag Archipelago no doubt sympathize with Solzhenitsyn's fantasy of armed resistance to Stalin's mass arrest. The difference between those readers and Cox, at least in part, a personality more inclined to anxiety, and a cultural political milieu that encouraged such fears. Sealed at Exhibit A at 14, describing how Cox's anxiety was augmented and shaped by numerous contemporaries who shared apprehensions about government and the breakdown of society more broadly. The comparative danger of non-contingent conspiracies in which ideas were not subject to vigorous debate is illustrated by examples of other federal murder conspiracy convictions. Other cases in which defendants have been sentenced in federal court for conspiracy to murder were not based on contingent agreements. They were not waiting for an unprecedented event on a historical scale to occur before engaging in violence. They were looking only for the opportunity to kill. For example, in United States versus Croft, a defendant received a 5-year sentence where 3 government witnesses testified that after a co-conspirator proposed murdering the United States attorney, the defendant made statements calculated to induce the other commune members to support the scheme. Moreover, witnesses testified that the defendant later took account of who was in and or out of the scheme, became a member of the hit team, and mediated a dispute concerning who would be the one to pull the trigger. Blah, blah, blah in United States versus Stewart. The defendant Sattar was convicted of, among other things, conspiring to kill persons abroad by composing and audio recording a fatwa in the name of a terrorist religious leader that commanded the killing of the Jews wherever they are, UI, and wherever they are found. Blah, blah. In contrast, Cox never made an agreement to kill any federal officers wherever they are found, and Sattar's contingent plan was also much closer to fruition. The government offered proof that this fatwa was communicated to Atiyah, a terrorist group, military leader. Although the evidence may not have established any particular plan of action to execute the fatwa, a reasonable jury could have found beyond a reasonable doubt from the fatwa's exhortations and Atiyah's readiness to act on it that there was a concrete illegal objective to murder persons abroad. A review of the transcripts of various intercepted telephone conversations introduced into evidence, particularly the September 18, 2000 conversation involving Sattar, Taha, and another party, bolsters this conclusion. The discussion goes well beyond the abstract and contemplates the coordination with Atiyah of violent actions, presumably along the lines of the Luxor massacre. In light of such evidence, a rational jury could have found beyond a reasonable doubt the conspiracy existed. I.D. Sattar received a 288th month sentence. And in United States versus Dick, blah, 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 defendants received sentences of 30 and 17 years for a conspiracy to kill an FBI agent, in which one defendant's cellmate testified that the defendant had him pass on a message to a feigned hitman to the effect that the defendant wanted to have the FBI agent killed, and a co-conspirator then arranged for the FBI agent to come to a designated location. Mr. Cox's conspiracy conviction is far outside the heartland of the conspiracy to murder guideline. Even where the conspiracies were not fulfilled, his sentence should reflect the lower culpability his conviction reflects in comparison to other defendants to which the guideline would apply, and the much diminished risk to the targets of the conspiracy, whom he did not genuinely wish to kill, absent evidence they were decimating the rule of law in the United States. Part 3. Imperfect entrapment is a strong mitigating circumstance not previously argued or considered, and it supports a significant departure and variance in Mr. Cox's sentence. At trial, defense counsel failed to request jury instructions on entrapment, but instead pressed an entrapment by estoppel defense, which would only offer relief to some of the destructive and device and weapons charges and have marginal relevance to the overt acts alleged in the count 12 conspiracy charge. Docket 324 at blah blah. At the first sentencing hearing, counsel did not ask the court to consider imperfect entrapment, a ground for departure well established in the Ninth Circuit law, and instead raised sentencing entrapment as a ground for departure, another argument with application only to the guidelines for the destructive device and weapons convictions. Docket 543 at blah. Neither entrapment theory previously presented by defense counsel addressed the most serious charges of conspiracy and solicitation to murder federal officers, and thus the court had no reason to conduct an informed analysis or make a ruling regarding the traditional trial defense of entrapment or the imperfect entrapment departure grounding for sentencing. Imperfect entrapment for departure or variance is relevant to Mr. Cox's most serious remaining conviction, the conspiracy to murder federal officers. The United States versus McClellan, blah, blah, is the leading circuit authority on imperfect entrapment. Because that decision presents significant factual and legal parallels to the Cox's case, an extended analysis of McClellan and its application to Mr. Cox is offered here. The conspiracy to murder federal employees charges requires proof that there was an agreement, including a plan to murder federal employees, and at least one overt act supporting that conspiracy. Docket 430 at blah blah. The trial testimony established that the government informants understood that evidence of a plan was important to the investigation and to their roles in the investigation. Both Bill Fulton and J.R. Olson pressed Cox at different times about a plan. The informants threatened, encouraged, and induced Mr. Cox to create or at least articulate a concrete plan of action. With Fulton, it centered on pushing for a plan of action regarding sovereign citizen arrest for state court judges. So his men's... Okay, I'm going to read the footnote of 6 and 7 at the bottom of page 21. There was no sentencing entrapment that had been shown here where the government piles it on just to get a higher sentence. Footnote 7. Contrary to court's instructions, the government in rebuttal argued, there's a lot of discussion by Ms. Hayden about you got a plan, right? Conspiracy doesn't require a plan, arguing that it only required the agreement, not a plan, to commit the crime of murder. You must find that there was a plan to commit at least one of the crimes alleged as an object of the conspiracy. Okay. With Fulton, it centered on pushing for a plan of action regarding sovereign citizen arrest warrants for state court judges so his men could execute a violent plan for their arrest. With Olson, it was repeated badgering about the 241, the Israeli retaliation plan. Mr. Cox pushed back against both Fulton and Olson, and ultimately his plan became leaving Alaska, with some vague and grandiose statements about returning at at some undetermined date to wage guerrilla warfare if necessary. An analysis of that evidence under the legal standards governing imperfect entrapment established this as a strong basis for re-sentence reduction, which the court should apply in making its sentencing decision. McClelland holds that even if the defendant first proposed the illegal action and continued on that path, but later expressed serious reservations or reluctance in the face of an informant's inducements, the defendant is less morally blameworthy and less dangerous to public safety. McClelland, 72, blah, blah. Comparing McClelland to Mr. Cox's case establishes that Mr. Cox presents a stronger case for mitigation than McClelland, because there were stronger inducements by the informants in Cox than in McClelland. Mr. Cox was less predisposed to take action than McClelland, and Mr. Cox showed much greater reluctance to move forward with murder than did McClelland. McClelland was convicted after a trial of a murder-for-hire scheme. It was not contradicted that McClelland initially approached his roommate, who later became a government informant and offered to pay him $10,000 to murder his estranged wife. That person went to the FBI, began to work for them as an informant, and recorded conversations with McClelland. McClelland was actively involved in planning the details of the murder, including purchasing airline tickets for the hitman, with a fake name, purchasing a poisoning device, directing the hitman how to construct it, helping him pack for the trip, giving him a map and pictures of his estranged wife, and driving him to the airport. ID at blah. A specific plan had been established for a specific target, and concrete steps were taken to consummate that plan. But there was also evidence that the hitman encouraged McClelland after he had received the unsolicited $10,000 offer. At various points during the planning stages, McClelland showed some reluctance to move forward with the plan. ID at blah. The jury was instructed but rejected the entrapment defense, and the trial judge denied the defense motions for an entrapment acquittal as a matter of law and outrageous government conduct. For sentencing, the district court nonetheless gave significant weight to imperfect entrapment, made a finding that it was present, and granted a 6-level departure in the sentencing guidelines. The Court of Appeals rejected the defendant's argument for dismissal based on outrageous government conduct and entrapment as a matter of law, conducting an extensive analysis of the predisposition and the inducement elements of that defense, and the 5 factors which must be considered when analyzing the predisposition prong. The court scrutinized the prodding employed by the hitman and concluded that it was a close call. Excuse me. I've been reading for almost an hour. Not even halfway done. And concluded that it was a close call, whether the defendant had met the inducement element, but upheld the district court's rejection of the entrapment defense because there was sufficient evidence to support finding against McClelland on 3 of the 5 factors relevant to predisposition. Then, turning to the government's appeal of the sentencing departure, the court found the imperfect entrapment as departure was justified even though McClelland initiated the murder-for-hire scheme. It found that such predisposition did not foreclose a departure because, unlike the trial defense, it is not predicated on government misconduct or deterrence of government misconduct, ID at blah, and it held that for imperfect entrapment, the most important of the 5 predisposition factors was whether the defendant showed any reluctance. The court tied its reasoning to the purposes of sentencing, stating that the imperfect entrapment may show that the defendant is both less morally blameworthy than an enthusiastic defendant and less likely to commit other crimes if not incarcerated. Quoting United States versus Garza Juarez, blah, blah, blah. It stated, a district court could properly determine that a defendant who first proposed an illegal scheme, but who later expressed serious reservations and acted only after strong and repeated inducements by the government is less morally blameworthy and less likely to commit crimes in the future than a defendant who eagerly participated in an illegal scheme with no inducement other than the initial suggestion by the government agent. Thus, if a district court departs downward on the ground of imperfect entrapment in a case in which the defendant first approached the government, the departure may still be completely consistent with at least two important factors relevant to sentencing protection of the public and characteristics particular to the defendant's culpability. Because the issue here is sentencing mitigation, the analysis will focus on those elements of entrapment identified by McClelland as most significant to the imperfect entrapment departure. Those include the government inducements, the nature of those inducements, Mr. Cox's reluctance in the face of those inducements, and how these facts relate to morally blameworthiness and future danger. As a matter of picking out a typo on page 21, it says of those twice. I should probably write that down. Oh my gosh. Part A, background on the involvement of informants Bill Fulton and J.R. Olson. FBI concern about Mr. Cox began with speeches he made in Montana in November 2009 when he described the Alaska Peacekeepers Militia as comprising 3,500 men and military-type tactical equipment. See Exhibit 4. Despite this concern early in the investigation, the FBI believed that Cox's claims were likely fictitious, that his militia credentials were dubious, and that established militia-related leaders in Montana had rejected his solution speech. Exhibit 5, blah, blah. Nevertheless, the government was sufficiently concerned that it opened a formal investigation into Mr. Cox in February of 2010, docket 625 at blah. Given Cox's outrageous statements and the number of people who had attended his events, the FBI had legitimate concerns and explored various methods to pursue an investigation of Mr. Cox. When Mr. Cox was charged with domestic violence involving his wife in February 2010, the FBI saw an opening that presented a variety of potential opportunities for the gathering of intelligence and prevention of violence. Exhibit 6 at 2, March 25, 2010, an intelligence meeting was held at the FBI office in Anchorage where AUSAs Bottini and Cooper opined that Cox had not crossed a line to the point of issuing subpoenas or national security letters. Shortly thereafter, Bill Fulton and J.R. Olson were inserted into the investigation as informants. Docket 632, blah, blah. Before Fulton and Olson became operational, some in the FBI continued to express doubt about his influence and whether Cox posed a threat. On April the 30th, 2010, Special Agent Milne wrote Cox has lost most of his local support, except for a handful of guys associated with the Alaska Peacekeepers Militia. 2 ATF and the local right-wing media are doing their best to distance themselves from him. Example 8, despite Cox's loss of support and their expressed uncertainty, if not misgivings, about the threat that he posed, the FBI moved forward with informants Bill Fulton and J.R. Olson. Both Fulton and Olson would receive substantial monetary benefits for their work. I'm going to read that again because Fulton said that he was not paid. Both Fulton and Olson would receive substantial monetary benefits for their work. The full extent of the payments they received was not revealed until after the trial, sentencing, and appeal in this matter. See Sealed Exhibit C. Most of the money received by Fulton and Olson was in large lump sum payments on February the 8th and 10th, 2013, after the defendants had been convicted and sentenced. Compare dockets, blah, blah, blah. Both informants likely knew during their work as informants on this case that the amount ultimately paid would be in part based on the success of developing a case for the most serious offenses, and those payments would be withheld until after the indictment, prosecution, and trial. J.R. Olson acknowledged as much in his trial testimony, blah, blah, who also benefited by avoiding criminal prosecution on an unrelated matter and who anticipated help with a restitution obligation on yet another criminal matter, testified that he hoped to ultimately be paid $300,000. He also testified that in early January 2011, he was specifically informed by the FBI that he had the opportunity to earn a substantial amount of money. Blah, blah. Olson knew of this monetary incentive before the 241 discussions, which began in early February 2011. Both Fulton and Olson were signed up as an informant on this investigation in May of 2010. Fulton and J.R. Olson's involvement spanned from early June 2010, when Fulton traveled to Fairbanks, met with Cox, and threatened him for not having a plan, to just before the arrest of Cox on March the 10th, 2011, while J.R. Olson was having almost daily contact with Cox and kept bringing up and pressing the concept of 241. B. Inducement and threats by Fulton and reluctance by Cox. In March 2010, an FBI agent wrote that Cox's domestic violence arrest involving his wife Marty presented an opportunity to gather intelligence and to perhaps prevent violence. It was the arrest which spawned the Alaska Office of Children's Service to look into the welfare of Cox's son, blah blah, and Cox's concern that OCS would attempt to remove S from the family home. On May the 26th, 2010, FBI agent Klein recommended that Bill Fulton, an Anchorage bounty hunter and the owner of Drop Zone, a military surplus store, be inserted as an undercover informant. Exhibit 9, Agent Klein noted that Aaron Bennett, the owner of Far North Tactical, a sporting goods and survivalist supply business in Fairbanks, had invited Fulton to set up a table and booth for an event at that store, where Cox would also have a booth set up. Agent Klein stated that Fulton could also arrange for a dinner with Cox while in Fairbanks. Exhibit 9, Agent Klein's plan was to insert Fulton into the investigation so he could take a step back and let the relationship grow. As described below, that plan failed when, instead of stepping back and letting the relationship grow, Fulton went far off script by emphasizing his ability to bring violence, threatening Cox and Zerby with violence because they had no plan, defying FBI rules by surreptitiously recording Cox and others without FBI permission, later doing the same with one of the FBI agents, and then destroying the 2-hour recording which captured conversations of Fulton with others at both the Pikes Landing motel meeting and the next day's meeting at Blondie's. Blah blah. In June, when Fulton first met with Cox at Pikes Landing Motel, he attempted to take advantage of Cox's concerns about OCS and his son S by bringing up the topic almost immediately upon Cox's arrival in the motel room. Fulton, quote, "What the fuck is going on? Last time I talked to you, you were waiting for a warrant." Cox, inaudible. Fulton, quote, "No, they were going to come to your house and take your kid." Exhibit 12 at 3. Footnote 8 at the bottom of page 24. Fulton and Bennett were really close friends, were both bounty hunters, and had a personal and professional relationship. Docket 639 blah. Bennett, who was in Fairbanks, was in a position to gather information about Cox and pass it along to Fulton, who lived in Anchorage. Footnote 9. Because the surreptitious recording of the FBI agent in which Fulton played sections of the earlier recordings at Pikes Landing and Blondie's was preserved, only those portions selected by Fulton were later available for review. Fulton's undisputed attack on Les Zerby and Zerby's comment that they had no plan was not played for Agent Espeland, and thus not preserved in the recording of the meeting with Espeland. The next day at Blondie's, Cox showed up late for the meeting orchestrated by Bennett for Fulton. By the time Cox arrived with S, his 1.5-year-old son, Fulton was intoxicated, bragging about the violence he could inflict. He pressed Cox on having a plan to obtain the warrants and line up support so that he and his violent crew could execute those warrants by arresting state court judges and others. Fulton confronted Cox about having a plan, but Cox was confused about the purpose of the meeting. Docket blah blah. Cox was not endorsing a plan to arrest judges. blah blah. Nevertheless, Fulton wanted Cox to talk about the plan. They had purportedly discussed the day before at Pike's Landing to go after judges, but when Les Zerby, who had been present the day before at Pike's Landing, insisted that there was no plan, Fulton came at Zerby with a knife and assaulted him. Docket 638 blah blah. Consistent with Fulton's behavior that day, Anderson described Fulton as extremely gruff, a fat drunkard, rude, extremely violent, and a belligerent toward Cox. Docket 629 at blah. At trial, Fulton admitted having a knife, but denied pulling it. He acknowledged that he wanted Zerby and others to believe he had a knife and believed that the threat was real. Docket 638 at blah. He had portrayed himself as a man prone to violence and was described by his good friend Aaron Bennett as habitually carrying a firearm at his hip at all times, with a round racked in the chamber and the hammer back. Docket 639 at blah. Consistent with Fulton's desire to create an atmosphere of danger and anxiety at the Blondies' meeting, he exerted control by taking everyone's cell phones and having his assistant stand guard with a sawed-off shotgun. Docket 639 at blah. Mr. Fulton was purportedly under direction and control of Special Agent Klein and Espeland, but neither agent was present in Fairbanks during the time of these events, and Agent Sutherland, who was assigned to Fairbanks, was not working that day. Docket blah blah. After the Blondies incident in Fairbanks in June of 2010, Fulton had no personal contact with Cox and limited phone and text communications. However, in early February 2011, Cox asked Vernon and Olson to attend the Anchorage Militia Convention, in part because he did not wish to be near Fulton and because his wife had just given birth to his daughter. B. Fulton met with J.R. Olson and Lonnie Vernon during the convention and told them he had been serious about wanting to kill Zerby, and stated, Mr. Fulton, quote, I was gonna fucking end his existence on this planet. Yeah, I was not fucking around at all. What happened was, that was the last summer when Schaeffer didn't know which way it was going to go with the cops, whether or not they were going to come to try to take his kid. And Zerby's like, well, we don't have a plan. I just fucking lost it. I literally grabbed a knife, started coming over the counter, and I was like, I'll fucking slit your throat open and audible, you fucking piece of shit. What do you mean you don't have a fucking plan? I was like, that's all you guys do is fucking plan. What the fuck is your plan? Well, we thought you guys would have one. Exhibit 13. Cox had earlier told Vernon and Olson to be wary of Fulton, describing him as a brutish guy who needed someone temperate like Cox. Exhibit 14 at 4-5. Thus, Cox was not only afraid of Fulton, he pushed back against Fulton's threats to establish a plan of action involving OCS, and instead ultimately followed law procedures to resolve that dispute. Part C. Inducement by J.R. Olson and reluctance by Cox. The indictment alleged that on February the 12th, 2011, Cox and others, anticipating Cox's plan to not attend a court hearing, had developed a 2-4-1 plan, that if any of them were killed, the others should kill two opponents, specifically law enforcement, judges, or district attorneys. Docket 239 at blah. Olson consistently pushed the 2-4-1 concept, bringing it up on a routine basis, even after being admonished by the FBI in response to AUSA Scrocky's complaint about Olson. The genesis for the 2-4-1 discussion was likely Olson and Vernon's conversation with Fulton at the militia convention at the Millennial Hotel in Anchorage, February 5th, 2011, docket blah blah. Olson remarked that we need to make it clear that he, Cox, needs to have a plan. If he was not going to appear in court, Exhibit 15 at 15, Vernon said Cox was saying he was just not going to go. But Vernon wondered, then what? ID at 17. Olson implied that Cox would be gone once arrested, meaning killed. After returning from Anchorage, Olson met with Cox on February 6 at a Super Bowl Sunday gathering. Olson claimed that the meeting was unrecorded because his recorder malfunctioned, docket 633 at 13. Cox testified that Olson brought up the Israeli policy of 1-for-1 or 1-for-1. that for any one Israeli killed, one member of the enemy would be killed, and that it was Olson who wanted to inject this concept into the discussions with others in their group because Olson had met with Fulton the previous day. Cox perceived him to be supporting Fulton's violent tendencies and was deeply alarmed. He expressed to Olson his opposition to a 241 plan, but said he would bring the issue up at the next meeting. Docket 641 at Blah. Olson testified that it was Cox who first brought up a 241 and that it was first raised at the February 12th meeting in Ken Thessing's bus. Docket 632 at Blah. While Cox is prone to exaggeration, his testimony that the 241 issue was raised by Olson on February 6, 6 days before the Thessing bus meeting, is corroborated by Olson's statement in Anchorage on February the 5th that they needed to make it clear to Cox he needs to have a plan. If he is not going to appear in court, Cox brought up the Israeli defense policy on February the 12th as one item on a list he wanted discussed, and he testified it was on the list based on Olson's raising the topic from the previous day. The almost academic nature of the discussion of this topic on February the 12th is consistent with a topic suggested by Olson and brought to the table by Cox. However, even if one were to accept Olson's testimony that Cox first brought this up, it was Olson who continually pursued discussion of a 141, 241, and even suggested a 541, and it was Olson who tried to prod Cox into turning this concept into a concrete plan with directions for himself and others in the group. The facts on this point were well developed in Mr. Cox's first sentencing memorandum, but those facts were not linked to the imperfect entrapment departure ground argued here, docket 543 at Blah. It bears emphasizing that even the government was troubled by the actions of Olson. From Stephen Scrocky, sent February 13, 2011, 4:13 p.m. To Karen Loeffler. Subject Cox. Long email, sorry. Listened to the conversation from last night. In summary, they are kicking around ideas. My advice, do not arrest him if he doesn't show, but issue the warrant and let it sit. With the source in place, we'll have the best idea of what's going on, and it won't agitate Cox's followers. You might want to give Mike Gray and the SAC a call tonight too. The SAC can verify with Rick what I'm saying. 241 stands for if they take one of us, we take two of them. But they discuss not being strong enough to impose their views on the rule of law. They discuss everything from 241 to fleeing to the rapture, coming and waiting for that. In my view, the FBI source is pushing Cox a bit too hard on not getting arrested, and the source agrees too much in moving their plans forward, which would generate a response, whether violent or not. The source adds, why don't we make it 541? Not a good idea. FBI has to fix this. After some discussion of a 241, Cox says, we're just speculating here, and I want to hear where you stand. Cox does say he would be morally correct in shooting a judge, but adds that he doesn't want to do that. So he makes a big pronouncement, then backs off. The typical I will, but not just yet type stuff. Exhibit 16 at 1, emphasis added. This concern about Olson's behavior was communicated to Olson by Agent Sutherland, who cautioned Olson to not try to elicit evidence or try too hard to make a case, and was reminded that his tasking was to collect intelligence and to report the plans and the thoughts of the group without unduly influencing the group. Olson's continual prodding on this theory is relevant to the imperfect entrapment departure. In a February 15th conversation with Cox and Vernon, Olson raises the 241, saying, we need some kind of code, 241 code. Exhibit 18 at 5. On February 19th, the same day, the Sutherland reports that he had admonished Olson. Olson raised 241 with Cox at Coleman Barney's house. At what point do the 241 kick in? Cox downplays 241, showing reluctance, and also commenting, I'm hoping Lonnie was just kidding, blowing off some steam or something. Exhibit 19. After more discussion from Cox about his plans to flee and how he is no longer a leader, Olson comments that it may be our turn to jump in the hot seat. and ask what else can he do. The 2-for-1, I'd be willing to, to do something like that if he need to get some attention. If need be to get some attention. Exhibit 20 at 8. Cox shows reluctance by saying it would be no good for them to die just because he went to prison, but Olson persists by commenting, I'd rather die a free man than being in bondage with them. ID at blah. Olson pushed on a 2-for-1 for a third time on February 19th, but in response to Cox cautioning they all have a lot to lose, that they primarily care about their families and businesses, that he is not motivated by seeing heads roll, that he is motivated by wanting his family to live free and prosperous and happy life, and that 2-for-1 did not make sense at that time. Olson steers the conversation to what happens when they start grabbing us one by one, and wants to know if 2-for-1 is then initiated by those who are still outside. How do we determine when the scales are tipped? ID at blah. The discussion continues with no resolution other than Cox clearly taking the position that 2-for-1 was premature. While not directly relevant to Olson's prodding, Cox's reluctance to pursue violence is further demonstrated by comments and concerns he expressed on February the 12th about Aaron Bennett trying to create a wedge between him and Thessing. Mr. Cox, he's Aaron Bennett constantly pushing me. You've got to just fight and start killing, and figure it out later, and I'm being very temperate and no hold back. Let's not be premature, That's just retaliation. That's just vindictive, Whoa, oh, Nelly, pump your brakes, Mr. Olson put the reins on. Mr. Cox, and he gets sick of me saying pump your brakes too much. And now I think where he's at is he's trying to destroy me because I'm a cork in the bottleneck, emphasis added. Bennett was a close friend of Bill Fulton, who had both a business and a personal relationship with Fulton. He helped Fulton set up the meeting with Cox in June of 2010. Part D. Cox's decision and preparations to flee as a powerful evidence of reluctance. The government will argue that Cox's decision to pack up his family and all their belongings and to escape Alaska was a temporary move because Cox had stated that he intended to return and fight guerrilla warfare at some later date. This view contradicts the numerous emails and memos over the entire course of this investigation in which the prosecutors and agents openly mocked most of Cox's claim. Those reports noted that he had little to no support in the militia community and that he had developed no concrete plans for action. Exhibit 5, Cox's claims are likely fictitious. Exhibit 7, AUSA's opine that Cox has not crossed the line. Exhibit 8, Cox has lost most of his local support. Exhibit 22, Cox was exposed as a fraud, took a beating, and lost all of his support in Alaska, Idaho, and Montana. Exhibit 16, AUSA Scrocky, Cox is full of it. He's a legend in his own mind. Cox is self-absorbed, narcissistic, and an emperor with no clothes. I don't know if this sums this group up, but it's not the stuff of revolutionaries. Exhibit 23, Sutherland reports he listened to most of the February the 12th audio and states do not feel it supports prosecution and recommends holding the agents in Anchorage until they can discuss the matter further. Cox and his family moved out of their house on February 13th, 2011 and moved in with the Vernons on February 14th. Mr. Cox failed to appear for his minor court hearing in the state court and began preparations to flee Alaska with his family and their belongings. By February the 15th, the FBI learned of Cox's plans to flee. At that point, they had already budgeted for a substantial TDY of FBI agents for Fairbanks. In an email from Agent Sutherland, he stated that they expect Cox to flee in 24 to 48 hours. So, we have lots of legal and strategy questions. Exhibit 24 on February the 20th, 2011, United States Attorney Karen Loeffler discusses a plan to provide a truck and driver to take Cox across the border into Canada. Exhibit 25 on February the 21st, 2011, the FBI learned that Cox was liquidating everything he owned. Exhibit 26, by February 26, 2011, the FBI knew that Cox was fatigued and ready to go, ready to leave with a trucker, and that he was also making wanted posters of himself as Robin Hood, presumably to leave behind. Exhibit 27. After Lonnie Vernon angrily kicked Cox and his family out of his house on February 19th, Cox, his wife, and his 2 children moved in with Coleman Barney and continued with their plans to flee Alaska with all of their belongings. From this point forward until the orchestrated grenade and silencer transactions and the arrest on March the 10th, J.R. Olson was working both the government's fictitious plan to assist in Cox's escape with trucker Han Solo and brokering the deal for the purchase of some hand grenades and silencers that Bill Fulton claimed he could supply. Olson was also pushing Lonnie Vernon to buy a neat toy from Fulton, Exhibit 28 at 8, and it was Olson who placed the weapons order with Fulton directly by the phone on February 26, 2011. Untranscribed audio, blah blah. Part E. The evidence of imperfect entrapment as a mitigating factor establishing Mr. Cox is less morally blameworthy and less dangerous than someone who would eagerly pursue an agreement and a plan to kill federal employees. A defendant who ultimately expresses serious reservations about illegal conduct he may have initially proposed or even pursued is less morally blameworthy and less likely to commit crimes in the future. McClelland, blah blah. This departure fits Mr. Cox. When this offense is alleged to have begun, Mr. Cox was a young man with no history of violent behavior. He had been employed or ran his own business since he was a teenager. He ran for public office and lost. He then began making speeches to militia and Second Amendment groups in Alaska and elsewhere. He made up facts and exaggerated the size of his militia and the equipment he had to support it. Initially, he drew large crowds, but eventually he lost support in Alaska and elsewhere when it became apparent that he was a bullshitter, or as described by AUSA Scrocky, the emperor with no clothes. He continued to make outrageous statements and comments, even in a state court hearing, which he turned into a publicity stunt, telling a judge that some people would not have a problem seeing the judge dead, and telling a court security officer he had them outgunned. He also traveled wearing a bulletproof vest and carrying a concealed weapon when giving a speech at a radio station and visiting with a police officer who was a former neighbor. For these and other reasons, federal and local law enforcement understandably became concerned and pursued their investigation of Cox. Character and reputation as a factor relevant to the predisposition prong of entrapment or imperfect entrapment should be viewed with respect to predisposition to commit the most serious crime of conviction. Conspiracy to murder federal officers and employees, Mr. Cox had developed a reputation among the militia community as a blowhard, not as a man of action capable of committing violence. And while that is not a character trait to be trumpeted, the character is inconsistent with a person who is likely to take action or be able to lead others into action. Most significantly, for a departure based on imperfect entrapment, it is the factors of inducement, the nature of that inducement, and the reluctance in the face of such inducement which are most relevant to moral culpability and future dangerousness. Despite Mr. Cox's outrageous speeches and bombastic comments suggesting violence in conversations with Fulton, Olson, Barney, and the Vernons, he repeatedly pushed back against calls to action or for concrete plans to commit violence. He demonstrated reluctance throughout the time of this alleged conspiracy, reluctance about suggestions of violence made by the informants, by Aaron Bennett, Fulton friend, and others allegedly involved in this conspiracy. His reluctance is also demonstrated by his decision to take his family to Fort Wainwright to seek asylum rather than engage in a violent confrontation with law enforcement. Exhibit 29. Cox, apparently believing he was the target of a fictitious federal hit team, showed reluctance at the resorting to violence and instead sought protection at Fort Wainwright. Whether one views this event as a sincere concern for his safety and the safety of his family, or a form of political theater, it demonstrates reluctance to engage in violence. Between June and November, there was no specific plans to commit violence against any particular target. On November the 19th, 2010, there was a militia event attended by J.R. Olson to discuss publicity to the press and security for an upcoming state court hearing at the KJNP, King James North Pole radio station, Exhibit 30. The entire security plan was to be defensive in posture and to only use force in self-defense. Cox made comments again demonstrating reluctance to use physical or violent force. It would be horrible to kill a cop. Cox stated that they would need to be prepared to kill in defense of Judge Bartell or Marty. But when J.R. Olson interjected, "Yeah, be ready to," Cox interjected with, "We would want to avoid killing at all cost." In an earlier portion of this recording, a section not played for the jury, Cox stated, "The reason that we need to do this is not so that we can go off and, pick a fight and start bloodshed, but so that we can prevent it. I mean, none of us want anything except to, watch cartoons with our kids and make the lawn look nice and go fishing and, have a good time. That's what we just want, domestic tranquility, like it says." Cox also showed no interest in M16 rifles when suggested by Olson, docket 634 at Blah, and at other times made statements like "bluff it, pray, and train," and in the meantime, "total Gandhi," and "the grenades scare me." In sum, there is far greater evidence of reluctance displayed by Mr. Cox throughout the time of his conspiracy than found to exist in McClelland, which justified a 6-level downward departure. Part 4. Mr. Cox's mental health and the court's concern about future dangerousness. A. The court was misled by the psychological evaluation presented at the first sentencing hearing. At Mr. Cox's original sentencing, the court expressed strong concern about Mr. Cox being dangerous, stating his personality and mental status as described by Mr. Ledoux indicates to me that the public needs to be protected from him, finding that the results of Mr. Ledoux's psychological exam were pretty accurate, that Mr. Cox needs continuing long-term medical care, and that the court was not at all satisfied that he would get that outside of incarceration. At that time, the court had before it the inaccurate and misleading psychological evaluation prepared by Dr. Robin Ledoux, which concluded that he was a paranoid schizophrenic and needed to be medicated. Docket 543 at Blah. The diagnosis and treatment recommendations from the report have now been debunked by both BOP mental health professionals and the thorough psychological evaluation prepared by Dr. Mark Cunningham. See Exhibit Blah. Dr. Ledoux had diagnosed Mr. Cox as a paranoid schizophrenic and suffering from delusional personality disorder and paranoid personality disorder. She concluded that Mr. Cox needs mental health treatment for the rest of his life, needs to be monitored closely to ensure he is taking appropriate medication, and that he is a man with a severe mental illness. Docket 543 Blah. None of these conclusions are supported by BOP mental health professionals or Dr. Cunningham. The dangerousness concerns expressed by the court at the first sentencing are understandable given the report prepared by Dr. Ledoux. But the basis for those concerns are no longer supported because Dr. Ledoux's diagnosis and recommendations are simply wrong. Her findings and recommendations are not supported by the facts of the case, witness interviews, reports about Mr. Cox since he was sent to prison, or the diagnostic manual. Mental health records from BOP for Mr. Cox's stay at both FDC CTAC and the Marion CMU completely reject Dr. Ledoux's diagnosis. BOP mental health professionals have not required or recommended mental health treatment as suggested by Dr. Ledoux. Upon arrival at the Marion CMU, Dr. Marla Patterson, a BOP psychologist, reviewed Dr. Ledoux's report, met with Mr. Cox, and wrote the following. Inmate Cox was the subject of a psychological evaluation requested by the defense attorney. See attached report. The conclusion of this evaluation was diagnosis of Axis 1, paranoid schizophrenia, Axis 2, delusional personality disorder, and paranoid personality disorder. The accuracy of these diagnoses is questionable. Noteworthy is that there is no delusional personality disorder listed in the DSM. The information provided might be better accounted for by understanding the cultural context of his behavior, given he was associating with and strongly identifying with a group of militant individuals. Cox has no other reported mental health history, treatment, or psychopharmacological medication use. Sealed Exhibit B at 11, she also wrote, "No programs, treatments are recommended at this time. The additional mental health records provided by BOP are consistent with the views expressed by Dr. Patterson. Dr. Cox is not involved in mental health treatment or medication, and neither medication nor treatment have been recommended for him. Dr. Cunningham's thorough and well-documented report supports the conclusions reached by the BOP mental health professionals and sets forth in detail why the diagnosis of Dr. Ledoux are not supported by any objective or psychologically sound analysis." Sealed Exhibit A at 6-9. Dr. Cunningham reaches diagnostic impressions about Mr. Cox, but concludes that he does not suffer from severe mental illness identified by Dr. Ledoux, and that Mr. Cox's psychological problems do not make him dangerous and do not require lifetime treatment. With respect to medication, Dr. Cunningham, like the BOP, does not see a present need, but he notes that Mr. Cox's cyclic mood disorder, which is mild at present, resurges. It is treatable with mood-stabilizing drugs. None of Cunningham's findings rise to the level of concern that the court identified at Mr. Cox's first sentencing, and neither Dr. Cunningham nor the BOP suggest a need to manage mental health issues for Mr. Cox in a custodial setting. It is indisputed that other than the domestic violence episodes with his wife, Mr. Cox has never attacked, assaulted, or physically harmed another human being. To the extent that dangerousness concerns about Mr. Cox center on his past inflamed rhetoric and a concern that he will incite others to unlawful action, one must dig deeper into the record and the discovery to see that those concerns are undermined by views expressed by government agents, by Mr. Cox's reluctance whenever pressed into making a plan of action, and his decisions to seek asylum or flee from Alaska when he felt that he was under imminent threat of danger. Hold on. Wow, we got a lot of reading still to go. All right, let's continue on here. Part B, concern about Mr. Cox's ability to influence others. The discovery materials reveal that the FBI not only had doubts about Mr. Cox's militia and ordnance claims, they also doubted his ability to influence others. On April the 30th, 2010, before the informants were even introduced to Mr. Cox, Special Agent Milne wrote, "Cox has lost most of his local support except for a handful of guys associated with the Alaska Peacekeepers Militia, 2ATF, and the local right-wing media are doing their best to distance themselves from him." Exhibit 8. After Cox's meeting with FBI informant Bill Fulton in June of 2010, in which Fulton threatened Cox about having a plan and pulled a knife on Les Zerbe, Special Agent Espelin wrote an email to other agents that Cox took a verbal beating at the general meeting last night. Most likely lost all of his support in Alaska, Idaho, and Montana. Any plans for revolution took a giant step back. Exhibit 22. And when asked why Cox took a beating, Agent Espelin responded, SC was exposed as a self-aggrandizing fraud. He did not have a plan at all. Even if he had a plan, there were allegedly other plans to off SC 48 hours after the revolution began. SC has gone from a cadre of 24 down to 2, him and his number 2, Les Zerbe. By February 2011, interest in Cox's speeches and his influence on his co-conspirators had waned. There are repeated references to these facts in the email traffic among the FBI agents and AUSA Scrocky, with Mr. Scrocky hitting the nail on the head when he described Cox as the emperor with no clothes. Exhibit 16 at 2. Mr. Cox was also losing sway over his followers. Lonnie Vernon was fed up with Cox and with Cox's reluctance to take action, and on February the 19th, 2 weeks before the arrest, he kicked Cox and his family out of his house, requiring Cox to move in with Coleman Barney while awaiting Han Solo, the trucker, retained by Gerald J.R. Olson, to Spirit Cox out of Alaska. Vernon attacked Cox, telling him, "Stand up for yourself, and you never have your ducks in a row." Exhibit 20 at 2-3. After this February 19th falling out with Lonnie Vernon, Cox had very little contact with Vernon, while Olson continued communicating with Vernon on a regular basis. Based on the undercover recordings played at trial, Olson was brokering separate deals for weapons between the Vernons and Fulton, and Cox and Barney and Fulton. The controlled deliveries of the weapons and the arrest which followed were also separately orchestrated. This separation is further evidence that Cox had lost influence over Vernon, and that the Vernons were now acting separately and apart from Cox and Barney. C. None of the federal employees identified by the government for the conspiracy to murder charge were placed in the actual danger of physical harm. In January 18, 2011, FBI budgeting memo for a 90-day TDY assignment of agents from Anchorage to Fairbanks and a request for funding for 4 confidential human resources, it states that Cox has not specifically threatened law enforcement officers in the Fairbanks area. He has indicated that blood may be shed in the future. Exhibit 33 at 2. A name search of the almost 12,000 pages of transcripts created from the undercover audio reveals no mention of Nanette Curtis, Tom Studler, Trina Bootcamp, or Jimmy Johnson. The 4 names found buried in Michael Anderson's legal pad and field notebook amongst writings and entries completely unrelated to this matter, Exhibits 34 and 35, and as Anderson testified, he did not follow up investigation on any of these names, and the names were entered well before the arrest of Cox and others. There is no evidence in the record or elsewhere suggesting that any actions were about to be taken against these federal employees unless, at some undefined point in the future, the United States devolved into Stalin-esque martial law, and they participated in breaking down doors and making mass arrests. While the 4 names on trial, Exhibits 504 and 506, represent the basis for Mr. Cox's conviction, those names were never a point of discussion among Barney, the Vernons, Olson, Fulton, or Bennett. The names were not even discussed between Anderson and Cox in any concrete fashion. Jimmy Johnson was unknown to Cox, and his name went into the field manually solely because Anderson saw the name in a news article and considered researching him in connection with the fictitious federal hit team which Cox had conjured up. Docket 629 at Blah. The TSA agent names were provided by Mr. Cox and written down on a legal pad buried among pages of unrelated writings and forgotten by Anderson, only surfacing when the search warrants were later executed in March of 2011. Docket 629 at Blah. Cox made a comment in relation to Trina Bootcamp that was generally related to her participating in the unlikely event of Stalin-esque martial law. Anderson conducted no research on those names. D. Mr. Cox's outrageous and offensive statements. Mr. Cox, at a misdemeanor hearing in a state court, appeared with a security team and 36 supporters. He commented to the state court judge that some people, those that should be kicked out of the militia, would rather kill you than argue with you in court. And then, as he was leaving, told a court security officer, "You're outmanned and outgunned, and we could have you all dead in one night." Docket 636 at Blah. Coleman Barney testified that Cox went off script and shocked everyone. Docket 642 Blah. Agent Sutherland reported that there were 36 supporters there for Cox and that everyone left without incident. Exhibit 36. His lack of insight about the effect of such comments is demonstrated by text he later sent to Philip Brandon that the officer to whom he made the comment was a cool guy who is totally on our side. Exhibit 37. Cox also had verbal exchanges with TSA officials, including Tom Studler, at the airport, asking to speak with a supervisor about his constitutional concerns. But it was also reported by some in the TSA that he left the airport with no problems, that his demeanor was pretty respectful, and at no time during the private screening did Cox make any threats. Exhibit 38. Nevertheless, these unnecessary conflicts with low-level security personnel demonstrate the lack of insight and attention-seeking behavior discussed at various points in Dr. Cunningham's report, sealed Exhibit A. Part E. Cox's ability to find pro-social avenues to address conflict and to discern more meaningful solutions to the problems. At the trial, Mr. Cox was portrayed as a militia leader, sovereign citizen, and person who would not employ normal channels of dispute resolution. However, Mr. Cox has demonstrated the ability to work within the system with proper education, guidance, and support, and to resist those who advocate violence. As an example of this is how the OCS investigating involving his son S., who ultimately resolved. Most importantly, Cox resisted Fulton's entreaty to create a plan for violence and instead worked through his attorney Robert John and with OCS to ultimately resolve the matter amicably with the family and a psychologist, docket 630 blah. He accepted counsel from both his lawyer Robert John and from military police officer Stephen Gibson, who had reached out to Cox when he feared that law enforcement and Cox may be headed to a confrontation, docket 638 at blah. Gibson testified that he shared with Cox his similar experiences with OCS and recommended a psychiatrist to work with Cox, S, and OCS, and that helped resolve the problem, ID at blah. This clearly demonstrates Cox's ability to listen and reason. At some point during the period of the conspiracy, Mr. Cox came under the influence of the sovereign citizen movement and had meetings with various individuals in that movement over litigation strategy, creating their own court system and taking it to the point of having a trial of his domestic violence case at the Denny's restaurant with a Fox Judge Bartles. While concerning some of the reliance on these individuals can be seen as a method of avoiding violence, more importantly, since then, Mr. Cox has disavowed the sovereign citizen movement and determined that their ideology and tactics were false and did not work. Exhibit 39 at 3. This is confirmed by Dr. Cunningham's report, sealed Exhibit A at blah. Dr. Cunningham identifies these factors and others related to pro-social avenues available to Mr. Cox, which make his risk for committing or inspiring acts of serious violence very low. These include his strong family support and his occupational skills. Part 5. Conditions of confinement and danger in prison should be considered in determining the length of Mr. Cox's sentence. Once Mr. Cox was sentenced in January of 2013, he was designated and housed in the Communications Management Unit, first in Marion, Illinois, and more recently in Terre Haute, Indiana. Before his sentencing, Mr. Cox was in pretrial and pre-sentencing detention in general population at FTC SeaTac. He was permitted normal contact visitation with his parents, wife, children, and siblings. Once sentenced, that all changed, and he is now imprisoned under conditions described by a federal judge as inmates housed in CMUs, by contrast, may spend years denied contact with their loved ones and with diminished ability to communicate with them. The harms of these deprivations are heightened over time as children grow older and relationships with the outside become more difficult to maintain. Wilkerson versus Stalder. With each passing day, its effects are exponentially increased, just as surely as a single drop of water repeatedly, endlessly, will eventually bore through the hardest of stones. Since his arrival at the CMU in 2013, he has had one face-to-face visit with family members. While his continued confinement in the CMU may be in part related to his tendency to poke the bear, as described by Dr. Cunningham, those incarceration conditions are harsh and have a severely negative impact on mental health and maintaining pro-social relationships with family. This should be taken into account in determining how long of a prison sentence is necessary for this offense, and to what degree continued incarcerations has negative effects on rehabilitation and the other purposes of sentencing. The creation of the CMUs, how they are managed, and the decision-making process in which inmates are placed at CMUs have been the subject of criticism, controversy, and litigation. See link blah blah blah. The BOP claims that CMUs are designed to hold dangerous terrorists and other high-risk inmates, thus requiring heightened monitoring of their external and internal communications. However, many prisoners were sent to these units based on their unpopular political views, and many of these prisoners were brought to the CMU as a calculated means to integrate the units after critical press attention to the targeting of Muslims because of the high percentage of Muslim inmates assigned to the CMUs. The CMU has also proven to be a dangerous place for inmates housed there. The CMU at Terre Haute is a small and houses fewer than 50 inmates. In Mr. Cox's time there, one inmate has been stabbed and killed by another inmate, who then seriously wounded a second inmate before being subdued by a third inmate. The attacks on the inmates appeared to be motivated by animus from Muslim inmates against non-Muslim inmates at the CMU. The person who committed the murder had a list of names on the murder weapon and another list of names on a piece of paper. Part 6. Defense objections to probation guidelines calculations. Our objections are set forth in the attached March 22, 2019 letter to USPO Hensel and are summarized in Ms. Hensel's addendum to the final supplement to the pre-sentence report. Our objections letter is attached at Exhibit 1. We rely on that letter for our objections to the two-level adjustment for role in the offense and the denial of the acceptance of responsibility adjustment, final PSR, blah, blah, blah. With respect to our objection to the six-level adjustment applied pursuant to blah blah, we supplement the letter with the following argument. The blah 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 adjustment does not apply because Mr. Cox was not motivated to murder the 3 federal employees on Anderson's notepad because of their status as federal government employees. The final PSR assigns a 6-level adjustment to offense level based on the finding that the victim was a government office or employee. 2, the offense was conviction. That the offense of conviction was motivated by such status, blah, blah. The adjustment does not apply because the evidence fails to establish that the offense of conviction was motivated by the federal status of the victims, but rather their potential, but never fulfilled, roles as enforcers of Stalinesque martial law. Moreover, this adjustment requires a specified victim, while the contingent conspiracy upheld by the Ninth Circuit Court of Appeals under the broad rationale that the agreement standing alone constituted a sufficient general threat to the safety of a federal footnote at the bottom of page 43 or 46, depending on what place you're looking. Previous defense counsel objected to this adjustment under a double counting theory. Our objection is that this guideline adjustment requires far more than what is required for the offense of conviction. Not that it is redundant of what the offense of conviction establishes for the base offense level. However, the reason that 3A1.2 does not amount to impermissible double counting for convictions involving a single identifiable victim or a group of victims is that the guideline requires a higher level of culpability. The defendant's actions must have been motivated by the victim's official status. United States versus Woody, blah, blah, blah. Okay. The agreement standing alone constituted a sufficient general threat to the safety of a federal officer for purposes of liability under the statute. Does not require a specified victim. No specified federal victim ever became an agreed upon target for murder in this case. In Mr. Cox's case, blah, further requires the offense of conviction to have been motivated not just by the official status, but by the federal official status of a specified victim. Here, because the statute of conviction is violated only where there is a federal victim to establish jurisdiction of the offense, and because the offense of conviction must be motivated by such status, the analysis cannot take into account any state or local actors. The final PSR incorrectly identifies the 3 federal employees from Anderson's notepad and a 4th employee, U.S. Marshal, who was not known to Cox and whose name was a lone written entry in a separate yellow field book owned by Anderson as official victims. PSR at blah. See trial exhibits at blah blah. Anderson testified that Cox had asked him to add the names in the notepad, but not the yellow field book, to his database. But he never did. The Ninth Circuit did hold that the contingent conspiracy represented by this third theory, the theory that Cox and Anderson could consult this database in the event of government collapse and Stalinesque mass arrest to identify who was carrying out. Okay, the footnote at the bottom of page 47 or 44. We recognize that cases interpreting this motivated provision permit an enhancement when state officials or employees are the victims of a federal crime. United States versus Alexander, but Alexander involved the federal crime of interstate communication of threat to injure others in violation of 18 blah. which did not require federal victim and had interstate communication as its federal jurisdictional basis. This same is true of the cases cited in Blah, in which other circuits concluded the guideline could be applied to state officials. This federal victim restriction is confirmed by the fact that this enhancement, unlike other guideline enhancements, is limited to the specific victims of the offense of conviction and excludes other relevant conduct. Enhancement is proper only where a government official is a victim of a defendant's offense of conviction, because blah, the only other offense of conviction is to be considered the district court erred in considering other relevant conduct. Okay. Those unlawful arrest and kill them could rise to liability under the statute of conviction. However, Cox and Anderson were indifferent to the federal status of these individuals. Indeed, the database otherwise consisted entirely of state employees, and the conspiracy was not motivated by their employment status, but by their potential future acts, the carrying out of Stalinesque mass arrest or purges. This adjustment is not applicable because there is no specified individual victim that Mr. Cox was motivated to kill. Application Note 1 to Section 3A1.2 states that this guideline applies when specified individuals are victims of the offense. This guideline does not apply when the only victim is an organized agency or the government. A victim is a person who is directly and most seriously affected by the offense. A person who appeared on this list or database would not understand themselves to be potential murder victims unless they were planning on carrying out mass arrest at the behest of a Stalinesque government. It is completely inaccurate to say that the federal employees forgotten by Anderson and Cox at the time of their arrest were directly and most seriously affected by the offense. From the time of the conspiracy to the present, none of the individuals named participated in mass arrest or purges, the prerequisite for becoming an actual target of the conspiracy. Ultimately, there are no identifiable victims under the unusual circumstances of this offense. The victim is at most a hypothetical future government as an entity with no specified victims. Conclusion. Mr. Cox has paid dearly for the crimes he has committed. Any further period of incarceration is not necessary to further the goals of punishment or deterrence, and further imprisonment will undermine rehabilitation. Dated the 7th day of October 2019, respectfully submitted Michael Filipovic, Federal Defender, and K. Wagoner, Assistant Federal Defender, attorneys for Francis Schaeffer Cox. Certificate of Service. I certify that on October the 7th, 2019, I electronically filed the foregoing document with the clerk of the court using the CM-ECF system. I further certify I will mail a copy to Francis Schaeffer Cox. Susie Strait, Paralegal.